death penalty is nothing short of a colonial relic that has no place in Kenya today. Also, on a political level, so taking away the legal sphere, on a political level, what we have witnessed are examples of past presidents, leaders, opinion formers questioning the use of capital punishment and its continued existence in Kenya, and recognising themselves the psychological torture that this outdated punishment creates. And we've seen this play out really in practice, most importantly and effectively in the application of executive clemency, or commutations, however you wish to describe it. We saw that in the late 2000s when there were 4,000 people commuted. We saw it in 2016 with a further 2,500, and there have been other instances. It has been the only way in Kenya to reduce the death row population, because the provision of capital punishment for certain offences has meant that the death rows have been increasing exponentially each year, and only commutations would allow for that to go down. So Kenya's ADF status and its mass commutations are really the clearest indicators of the lack of any political will to actually execute. And we really must recognise that. There appears to be no real political will to execute in Kenya. But yet, abolition still has not happened. And what we have to do is question, I think, why that is so. Is it because it's convenient to keep it on the statute books? Is it that it might be needed in the future? Or is it just pure political expediency, that governments have concerns about abolition in a populist sense and therefore do nothing? But also I think we need to think about why, in a strange way, is there no desire to execute if you have it on the statute books? So these are all really important issues. And I think when we started this survey, this study, there were 600 people on death row. Now, what we know is there are thousands of people who have been sentenced to death and commuted, so no longer on death row. But if you look at the number of people who are affected by this law, it's actually thousands of people. But at the time of the survey, the study, there were only 600 people on death row. Next slide. So one area that I raised earlier is this issue about rationales for retention. And in all the countries that retain the death penalty, there are really three key reasons that can be identified for doing so. The first, and I've mentioned this, is the issue of public opinion, the idea that the public demands the death penalty for the most heinous offences, and that offenders, nothing less would be sufficient to avoid the public themselves taking justice into their own hands and seeking vengeance through non-judicial means. And related to that are two other rationales. This idea to satisfy sentencing principles of retribution, and to retain the death penalty and use the death penalty as a proportionate response to the offences and the most serious crimes. And also to use the death penalty to deter potentially violent offenders and thereby reduce the risk of violence. Chairperson Rosalind mentioned, when we came to Nairobi in June, July of last year, we presented the findings of our research on both the public opinion on the death penalty and those of what we called elite opinion formers. We sought their views on the death penalty. And some of you will remember that in relation to the public opinion survey, we found that only 51% actually supported retention of the death penalty. It's the lowest percentage that we've come across in the surveys that we've commissioned and Professor Caroline Hoyle has conducted. That is very, very low. So only 51%, but of that 51%, in fact, only 32% could be said to be strongly in favour or support the death penalty. We also found a significant reduction in support for retention, dropping to 28% when our respondents were asked if they would support the death penalty if it could be proved to some satisfaction or their satisfaction that innocent people were actually executed. And again, as Chairperson mentioned, there is absolutely no doubt in any system there will be mistakes, so innocent people will be executed. So that went down to 28%. Furthermore, 18% of those we interviewed were clear that capital punishment was considered inhumane. Of the second report that we did, the 42 opinion formers, we found that 90% were in favour of abolition. They were very worried about human rights abuses and about wrongful convictions, and they had low trust in the criminal justice system. So these were really, really important findings, and it really go to addressing some of the rationales for having the death penalty. And it was clear to us that the first rationale, that of public support, could not be sustained from the research that was conducted. But we couldn't address the other two rationales. So that's why we turned really to the third study, this study about looking at prisoners, looking at experiences and motivations and pathways to committing crimes. We wanted to explore the concerns also of abolitionists around the issue of human rights. So Carolyn will speak to these findings. Next slide, please. Before Carolyn goes into findings, just to say a few words about the actual sample. So we surveyed 671 prisoners across 12 prisons in Kenya. And for that, I really have to pay huge gratitude and thanks to both the team at KNCHR, did an absolutely amazing job to carry this out, and to the Commissioner of Prisons and to the prisons themselves, who really provided the most helpful cooperation to allow us to do this. Again, I mentioned that there are many more sentences to death, but of the people that we interviewed, 72% were death sentence prisoners. I think Carolyn can confirm this. Of the 671 prisoners, something just under 500 were actually prisoners under sentence of death. The others were those who were previously sentenced and now commuted. 95% were men, and the average time they spent on death row was 4 years and 2 months. What I found really interesting was the section on offences. The majority of those sentenced to death were for non-murder offences, so non-homicide offences. They were robbery with violence. 54% of our study were robbery with violence, 43% murder. And I think that's very, very important, because what we're really trying to say there is that in Kenya the death penalty exists, but because you have the death penalty for more than the offence of murder, actually what you find is that many people find themselves in the category of being sentenced to death for offences that may be considered really simple robbery, because the ingredients that are needed to become capital robbery are quite broad. So I think that's important. And what we did when we did this interview, we sought certain bits of information. We sought information about the lives of the prisoners at the time they committed their offences, their socioeconomic status, and any vulnerabilities and disadvantages. We looked at their pathways, their motivations for offending, including why they weren't deterred by harsh punishments. And we wanted to explore their experiences of the criminal justice system and imprisonment. I'm going to hand over to Carolyn now, and she's going to speak about the first two issues. The issues about whether these people are actually the worst of the worst offenders, as people assume them to be, and what really motivated them to commit these offences, and why the death penalty itself did not deter them. And I'll say something a little bit about the criminal justice system and incarceration. So I'm going to hand over to Professor Carolyn.
Good morning, everybody. Just before I start talking, can you go to the next slide, please? Just before I start talking about the findings, I just want to reiterate the point that Faye's made about the sample. The people we interviewed who were still on death row, we interviewed 81% of those on death row across the whole of Kenya. And I repeat that simply for the very point that those of you in the room who are statistically competent might soon work out that that's an incredibly high level of confidence. by which I mean, in layman's terms, we can absolutely know that the sample of people we interviewed is fully representative of all those on death row. And I think that's really important, so you don't think that we've kind of cherry-picked stories. And for that, I want to just reiterate my thanks to Kenya Prison Service. It's really phenomenal that they allowed us access to people on death row. It just doesn't happen in most countries, so this is a remarkable resource for people in Kenya to draw on. So Pervez introduced the three key rationales for the death penalty, or for retention of the death penalty: public opinion, deterrence. I've got so many microphones in front of me. It's quite remarkable. I can't even see my notes. Public opinion, deterrence, and retribution. And he talked a little bit about our previous work on public opinion, so I want to focus on the latter two of those, on deterrence and retribution. And really, when we talk about retribution, those who seek to justify what we might term as the moral permissibility of capital punishment in any jurisdictions really are talking about deservingness or desert. It's about what do the most serious offenders deserve by way of punishment. And in countries that have abolished the death penalty, this typically means life imprisonment, and that's what people clamour for when there's very, very serious offences. But in countries that retain the death penalty, they're looking for the death penalty as the most serious punishment. Now, international law has developed to a position where it's really agreed that in countries that have not yet abolished the death penalty, sentences of death should only be imposed for the most serious offences. And this was not really intended to justify continuing with the death penalty. It was simply a position that's evolved to say that until it's abolished, its application should be restricted to just those most serious crimes. And really, international law has evolved to a position where most serious offences is defined really as those nothing beyond intentional crimes with lethal or other extremely grave consequences. In other words, they said homicide. And you'll remember from the data he put up that half the people on death row in Kenya are not in there for homicide, they're in there for robbery. Now, seriousness is a subjective notion. It remains contentious in different jurisdictions, certainly in the ones that we work in across Asia, for example. But it's generally agreed that it means murder. So we have here a population, half of whom on the face of it do not appear under international law to be the most serious offenders. Now, when the public talk about the most serious offenders, they're not only talking about the offence, though. They're talking about a sense of who these people are who are on death row. They're seen not just as people committing serious offences, but the worst of the worst offenders. Now, the only other country that we have seen a survey of this rigour and this comprehensiveness is in India. Other countries, for example, the US, have got snapshots of death rows in certain states, and we know from those snapshots that it's the most disadvantaged, and it's often African Americans in America who are on death row. But in India, they do have a comprehensive survey, so we were very excited to do the same thing in Kenya. And what you find in India is that those on death row are not necessarily the worst of the worst, they're the people who are the most disadvantaged, the most vulnerable. Next slide, please. So, what do we know? This is quite hard to see that slide, but I'll just talk you through it. Well, data that we gathered from the Kenyan prisoners show that more than 10% of the sample had never been in any formal education. More than 2/3 had only completed primary school, and almost half of these had only completed up to class 4 of primary education. Less than 2% had been to university. So, they're not the most educated people from Kenya. At the time of their offence, most of them, about 90%, were not in permanent full-time employment. Many were in very precarious work, and the vast majority, 79%, were in routine or semi-routine jobs. Again, only 1% were professionals or higher managers, so not very well educated in not particularly good jobs. And they earned on average below Kenya's living wage. Those convicted of robbery were particularly poor. They were earning less than those who were convicted of murder. And those findings, of course, speak to their greater financial need. And on that point, almost all of them, 89%, were supporting dependents, often children but other family members too. Not surprisingly, over a third were in debt. Next slide, please. Now, another indicator of disadvantage in most countries, especially across Africa, is language. And in Kenya, none of the people in our sample had English as a first language. And that, of course, is the language of government, of business, of law, of the media, higher education. The language of the more educated, the upwardly mobile, and only 2% spoke Swahili as a first language, much lower than across the nation, which is about 25%. Instead, they spoke a range of local languages. Next slide, please. Now, at the time of their arrest, 43% of the prisoners had been relying on alcohol, and almost a third have a history of alcohol or substance abuse. Now, these rates are quite a bit higher than the national average. Similarly, reported rates of cannabis use at the time of arrest were also higher than those rates we find across Kenya as a whole in the national health surveys that have been done. A greater proportion, 15%, had been experiencing mental health problems at the time that they committed the offence. Again, a greater proportion than we would expect to see across the national population. And on the whole, of the whole sample, 18% had experienced abuse in their home or from someone close to them. But the women that we interviewed, 30% of those had experienced abuse. So I think it's fair to say that our interviews paint a picture of a population who is not necessarily the worst of the worst. When they committed their crimes, they were relatively uneducated, they were comparatively poor, they were in low-level precarious jobs with little financial security, and yet they had considerable debts, they had considerable expectations on them by way of financial dependence. Higher rates of substance abuse, higher rates of mental health problems. Not necessarily the worst of the worst, but certainly the most disadvantaged, and certainly with a fair amount of vulnerabilities among them. And of course, these disadvantages and these vulnerabilities really might help us to understand their pathways into offending, the reasons why and the motivations for committing certain crimes, especially acquisitive crimes such as robbery. And this speaks to the issue of deterrence theory, which I'll go on to now. Next slide, please. So, deterrence theory is really this idea that for a potential offender to be deterred from committing a crime, they need to see the risks as salient. So it's claimed by deterrence theorists that they'll make a rational choice about whether to offend by deploying knowledge about the applicable laws and punishments. That means they need to know what those are, and then they weigh up the costs and the benefits of any possible offence. So this is the theory, right? And the idea is that they may be deterred if they think that it's likely that they will be caught, if they think it's likely they will be convicted, and if they think it's likely that they'll get a particularly harsh sentence. And that the negative prospect of all of those outweighs the possible rewards. And of course, with acquisitive crime like robbery, the rewards are obvious. Next slide, please. So, taking the first point, you'll recall that most of the prisoners were poorly educated, most did not have English or Swahili as a first language, and so may not have been able to access national media at the time of their offending. But whatever the reason, the vast majority, 95% of those convicted of robbery, did not know that it was punishable by death. And 86% of those convicted of murder did not know that that was punishable by death either. I think this is remarkable data. As for their ability to make a rational choice, there was little evidence that this was done by those convicted of murder, whose responses suggest they were in a heightened state of emotion when they committed their crime. So the most common reasons given by our participants who had been convicted of murder were that they were in a state of extreme emotion, that they were angry, that they'd been provoked, that they were acting in self-defence. And some 13% of those convicted of murder did not even consider the possible punishment when they were committing their crimes. Not terribly surprising given their emotional state at the time. Now, it's not surprising that most of those convicted of robbery were motivated by financial gain, given their relative poverty. But what was surprising to us is that only 4% of those convicted of robbery and only 8% of those convicted of murder thought about the possibility that they might be sentenced to death for their crimes. Less than a third said that knowledge of the law and the possible punishments had affected their behaviour at all. And almost a half were not even worried about imprisonment. This is a population committing offences really not thinking about the possible punitive repercussions of their actions. So overall, prisoners had not been worried, had not hesitated, had not been influenced in their decisions about whether or not to offend by concerns about the likely punishment. And when they were making the decision to commit the crime, the vast majority, 85% of participants, thought it was either unlikely or very unlikely that they would be arrested. 89% said it was unlikely that they would be imprisoned. So not only were those we interviewed obviously not deterred by the possibility of being sentenced to death because they were in prison, they'd done their offence, but they couldn't have been deterred. With that little knowledge about what the possible repercussions of their actions, they simply could not have been deterred. They didn't have the necessary understanding or comprehension of the risks. This means that deterrence theory is not a very helpful way of making sense of this population. And this is actually music to my ears because I've long thought that deterrence theory could not really explain the actions of people, especially in a heightened state of emotion, which most people are when they commit murder. But our data are really clear on this. They're really, really absolutely clear. They could not have been deterred. So when you take that key rationale that most retentions jurisdictions talk about, why they keep the death penalty, it just falls apart in the face of really rigorous empirical data. Now, of course, the same factors around vulnerability and disadvantage that describe the population that we've looked at and that might explain motivations or pathways into crime also might explain how well they fare through the criminal process by way of due process, what they get. And Pervez is going to, we said we're going to do a double act. 3 hours sleep and a double act on the stage, what could possibly go wrong? So Pervez is now going to talk a little bit about those due process protections before we conclude.
Thank you. We don't have much more to do. If you go to the next slide, please. For those of us who have legal background, the section that deals with prisoners' experiences of the criminal justice system, I think is very, very important. And in these interviews, as Professor Karen Hall has just described, the two other rationales that I mentioned at the beginning, outside of public opinion, the two rationales about retribution and deterrence are not supported by the interviews that were conducted with prisoners sentenced to death in Kenya. And I just wanted to focus for 2 minutes on this other issue, which was a real concern, as I mentioned, amongst abolitionists, and it was a real concern amongst the opinion formers, that in fact, from their understanding and experience, the death penalty in Kenya breaches human rights and dignity and exposes defendants to potential wrongful convictions and potential executions. Again, if you look at the study that we did earlier, the interviews that we conducted with opinion formers across Kenya found considerable concerns about the lack of due process protections for suspects and defendants in relation to capital offences. These are concerns that lawyers have, these are concerns that those who work in the criminal justice system have. And I think it's a very important issue. And the interviews with the prisoners in this survey suggest that opinion formers were right to be concerned about this issue, and that none of the rights that should uniformly be provided to all suspects and defendants at the point of arrest were provided to all the participants. And reference was made to this by other speakers. And if you just look at some of those stats that we uncovered, 49% were not given their their legal right to remain silent. 53% said they were not given any opportunity to speak to a legal representative or a lawyer. Half of them said they were coerced to make confessions or provide evidence that could be used against them. 47% were subjected to psychological torture, and 37% said physical abuse. And 35% were denied any breaks during interrogation. And these stats are really quite important because what they speak to really is this idea that if you have this kind of practice, the evidence that is used in a trial is really something that is considered to be very unreliable. You can't trust it. And what happens then is that trust, the unreliability, leads to wrongful convictions. Okay? And in some of those wrongful convictions, there are innocent people. Next slide, please. The other stats that we uncovered, and that I think are worth mentioning, was in relation to abuse of process during trial, or issues that go to fair trial rights. So, for example, you might not all be able to see this. 45% said they did not understand during trial what was actually happening, what was the process. Over 1 in 5 claimed not to have been legally represented, and we know that from our own experiences in capital robbery cases, that many are unrepresented. Certainly that was the case. That may have improved, but they were unrepresented at hearings. And 27% said they were denied an interpreter at trial. There's one stat that I find quite interesting, that when they talk about threats by police officers and threats by court officials, the threats by court officials, or officials as we might call them, is quite low. Threats by police officers, much higher. Again, that rings true to what our experiences are of people who come under the criminal justice system. So what we know is that of those who were represented, most had state-appointed lawyers at each stage. And of those interviewed, they were very unhappy with their performance. Now, that is not to say that every lawyer is bad. That is to say the system doesn't allow for good lawyers, because of remuneration, because of the process, to get involved, and therefore the pressure on other lawyers to do all of the cases creates perhaps bad legal representation, not just because this issue that they're not very good lawyers. I really object to the idea that every lawyer must be bad if they're representing people on a pro bono basis, or in a state representation. And what we know again is, if you look at stats like this, is that if you have this kind of system, mistakes will happen. And we know from our own experiences in developed nations, in well-resourced countries like the US, and the countries where we come from, the United Kingdom, we have a very developed and well-resourced legal system. And even in those systems, mistakes happen. So in a country that has real pressures on resources, there's absolutely no doubt that there will be problems with the legal system, and that will lead to wrongful convictions and potentially wrongful executions.
Okay, so to conclude, we asked the prisoners that we spoke with about their experiences of incarceration. And remember that 72% of them were still on death row, the others had had their sentences commuted to life. But regardless of their actual status at the time, what we know from research is that lengthy incarceration damages health, it damages significant relationships, and there's obviously an interaction between those two things. And 2/3 of our participants reported that their physical health had suffered since they'd been in prison, and just under 2/3 said their mental health had suffered. Again, 2/3 said their relationships with their families had worsened, and most participants reported that their families were coping badly Now, partly, you may recall me saying earlier that they had very many dependents. Most of them had not just one or two, but a few dependents. So coping badly might partly reflect that, but it also reflects the emotional trauma of having a family member, a loved one, on death row, with the stigma and the emotional burdens that that entails. But, and this was interesting to us, most prisoners had opportunities for work and recreation. And we heard about this before from the prison service, how this has changed in the past decade. And we found this to be so in our sample, because most had access to rehabilitation, and most reported healthy relationships with prison officers, suggesting that while the prison service in Kenya might struggle to provide adequate physical conditions of detention, it takes an apparently positive approach in the main to fostering rehabilitation and reform. Now, rehabilitation is of course of significant importance to all prisoners, but it's often denied to those sentenced to death in other jurisdictions. In many jurisdictions, people on death row are in solitary confinement and have little or no opportunities for any recreation or education outside of their prison cell. That wasn't the case here. So these rates were much higher and much more positive than we had anticipated, and seems to reflect, as I mentioned, this changed attitude of the Kenyan state towards prisoners on death row that's happened in the last 10 to 15 years. Coincident, or not coincidentally, at the same time as we've had a lot of mass commutations. And simply access to education has improved quite dramatically since the introduction of what I think is referred to as the open door policy. And we found that almost 3/4 of both groups of prisoners had received or were receiving education, and similarly the vast majority were able to take exercise. So prison life can be made more or less tolerable by prisoners' relationships with each other, with other prisoners, and with prison officers. And what was really interesting to me is only 2% of the people we interviewed reported bad relationships with prison officers, whereas more than 3/4, 79%, said the relationships with prison officers were excellent or good. Again, you just wouldn't find that in most jurisdictions that retain the death penalty. You certainly don't find it in the US. Last slide, please. So, though Kenya has not executed its death sentence prisoners for decades, and while death sentences do continue to be imposed, the threat of execution still remains while prisoners remained burdened with the stigma of a death sentence. And our report really reflects on the histories, the decision-making and the prison experiences of those prisoners. It provides an opportunity to really better understand the lives of those people who are fractured by a system that retains capital punishment. And I think it's fair to say that here in Kenya, our research shows that those on death row are not necessarily the worst of the worst. Over half, you'll recall, have been convicted of a non-fatal offence. Almost all had little or no education. They were of low social and economic status. They were the most disadvantaged, and they were quite vulnerable in terms of their mental health needs or dependencies. And as a consequence, really, they found themselves caught up in the criminal justice system that clearly offered, as Pervez pointed out, inadequate legal protections, putting them at a very high risk of being convicted. And while that would be wrong in any country, and it is wrong in any country, it's inevitably of much greater concern in a country that retains the death penalty, for the reasons that others have already articulated. So a death sentence here in Kenya, as elsewhere, can only ever be an affront to human dignity. As our research makes absolutely clear, it's ineffective, it doesn't deter here, and in our view, it's an intolerable punishment that really, when we looked at these key rationales of retribution and deterrence, is indefensible. Thank you very much for listening.
Thank you very much, Caroline and Pervez. And of course, I want to thank the team that we helped in putting this together.
the team of research assistants that travel to different parts of the country to get this data out here for analysis. I think at this point, I would want us to launch the report. And because we have a small podium, I would just want to invite some few organizations to join the chairperson. So I will invite our chairperson, Madam Roslyn Odede. Then I will invite Mr. Mwakazi from Kenya Prisons. Then we have Commissioner Sarah. Then we have a representation from the judiciary. Then we have Daktari from Kenya, from National Police Service. And we have Irungu from Amnesty International. So please come to the podium. Linesta. I think we'll stand here and hold the reports. Then we have the EU in. Carol, can you join us, please? And Commissioner Morara.
Yes, please. Yeah.
And ICJ. ICJ? Oh, and Peter. Peter. My apologies, Peter.
Excuse me.
Where's Peter? Uncle. Wilson? I know you are seated behind.
Can we have 2 lines?
I think for the we do another photo session once you're done.
Yeah. Mwisho.
Leave me now. Great. I think I know you share the name there.
Yeah.
Share, surveillance,